SABC, together with the Department of Justice and Constitutional Development, bring you the final verdict. In the pursuit of justice, we are all equal before the law. These are some of the stories that have led to the final verdict. The practice of Ukuthwala has hit the headlines recently, causing unprecedented outrage. What used to be a traditional isiXhosa courting ritual has become a hotbed of cultural controversy. But how did it get this way?
Ukuthwala, in its original sense, was about an arranged marriage. The girl child would not know that she had been promised. So on an appointed day, she would be sent on an errand. On the way there, this man would emerge from nowhere and simply take her.
Then they would then take you, put you at their home, and then send the message to your family that when you're looking for your daughter, please look this side.
After the girl has been taken home, then it is then that the parent will go and report to say, don't look around. Your daughter is somewhere where we're coming from. What we are here to try and build the relationship because of these two ones that are getting married now. So then the process will start off paying a lot. When the girl arrives at the man's home, the parents would have already arranged for clothes so that like umakoti, they are already there, the staff.
Ukuthwala in itself, when it is properly practiced and acceptable to the community members, is perfectly normal and is perfectly accepted in our law. It is when it is abused by others for their own ends that then we begin to experience problems.
Makulu. Makulu.
Previously, whoever abducted never slept with the woman he's abducted. And they never abducted young children. When they abducted the young woman, they would take the young woman to the mother or the sisters or whoever to sleep with them up until the negotiations and lobola has been paid.
The usual form of abuse is where a group of men will abduct a little girl, take her into a house, and then immediately seduce her or have intercourse with her. And then they claim that they're practicing Ukuthwala.
Things have changed. This practice, it's not done like it used to be done in the olden days. People now, you see people, they are just taking an advantage. They are doing criminal stuff and hide behind the culture to say, I've done this because it is my culture.
If one were to try and abuse the practice of Ukuthwala and, I'll say, forcibly take a female person and they are then charged, they face a number of offenses. It could be kidnapping if you're talking about somebody who's a major, could be abduction. If they had unconsented sexual intercourse with that person, they are looking at charges of rape. If there was physical violence involved, they are looking at another charge of assault. And each shall be a separate charge. And they may be found guilty on all of them and sentenced in respect of each one of them.
As an underage victim of a sexual offense, there were options available so that Lulama would not have to face her attacker. The sexual offences courts provide for underage victims to give evidence by means of closed-circuit camera with the assistance of a court-appointed intermediary.
Andiqondi ndizokwazi uyenza le nto mna. Andifuna ukumbona laa mntu.
Suba nexhala awusobe. Yabona, ngale headset I'll be able to hear everything that's going on in the court. Baza kubuza imibuzo embalwa nje. Uba unengxaki ndikucacisele and then ke unosuku uphendule qha. Yeva?
Bazothina abanye abantu xa benibona ke ngoku. Uzondibona ke ngoku.
Oh, jonga phako. Lithuba lakho eli lokumbonisa into kokuba womelele akuyo victim. Yaya kuzumyeka asuka phuncuke nale nto ayenzileyo. Sekulixesha ke ngoku.
An intermediary plays a role where, let's say, a minor who's a sexual complainant or a minor giving evidence in camera, which is away from the public and sometimes away from the accused, directs the questions to the child. So all the questions asked of the child are asked through this person. The intermediary takes the emotion out of the questions and simply seeks to get a straightforward answer from the child. So they will hear the question and repose it to the child, appropriate to the age of the child.
Coming up, as the trial gets underway, will Sipho be able to convince the court that his actions were all in the name of Thwala?
Ayikokuqhila ncamani wena i-act nje but ke nayo ichair funeka izulele uzama ubonakalisa uba yilwele ubuntombi bayo.
In terms of the Criminal Law, Sexual Offences and Related Matters Amendment Act, rape occurs when the accused unlawfully and intentionally commits an act of sexual penetration with a complainant without consent. The crime of abduction consists of unlawfully taking a minor from the control of her legal guardian with the intention of enabling marriage or sexual intercourse with that minor.
The appropriate definition for abduction is the forcible removal of a child, a minor child. It could be a boy, could be a girl, from his or her parents or legal guardian, whoever is responsible for the child, with an intention either of marrying them or having sexual intercourse with them.
We were looking, Ukuthwala, at the age of a girl who is in the age of getting married. When it was not used in a way that the age difference that is so big, you'll go and take this girl and marry this girl. No, you are looking at the age where you see that the girl now, she fits well that she can be a woman.
But now, as it is happening, they abduct 11-year-old, 12-year-old, 13-year-old children and rape them. The Bill of Rights provides that children's rights are paramount. But they have a right also to education, right to health. You know, all those rights are affected. Secondly, we have the Sexual Offences Act, which provides for the age of, where you can consent for sex. Even if you have consented, if you are below 16, both of you can be convicted. So people are governed by the laws of this country. People cannot live according to custom, which is not part of our law.
You cannot justify a man of the age of 59 who will go and take a girl at the age of 18 years or 15 years. You destroy her future, firstly. And in this country, we do have a constitution that talks about the human rights, which we all agree to this constitution. So we need to respect that. So things are not doing in that manner in the olden days. There is no involvement of parents in this process. They'll just abduct this girl and force to sleep with her and all those things. So it is not done in the way it used to be done. It's totally different. That is why I'm saying they are denting the image of our culture.
Nomzana Masiza, khawusixelele ngolwazi lwakho ngesithethe sokuthwala.
Sisithethe esisetyenziswa ngabantu bakuthi.
Seyile xesha elingakanani sikhona esi sithethe?
Hayi ke, andizuyazi kodwa seyilithutyana.
Ungakwazi ukunabisa kabanzi ngesi sithethe?
Well, kuxa i-out ithe yabona icherry ecinga mhlawumbe ngayenza umfazi wayo, then iye ivaye ke namajita wayo bahambe bayoyixhila kokwayo.
Bamxhile?
Hayi kokuxhila ncama wena i-act nje but ke nayo icherry funeka izulele uzama ubonakalisa uba ilwele ubuntombi bayo.
Then what happens?
Then ube uyayithatha iyohlala nawe nefamily yakho.
Iba yintoni injongo yaloo nto?
Kufuneka ibonakale kaloku uba ingakwazi nokwenza umfazi right.
And the couple, do they usually have intercourse that night?
Not usually, but ke ululama yena uyawazicelela. Yo, hayi ke nama ndabuya ngamva.
Objection, my lady. Does this defense have any evidence to support this claim?
Miss Mananga?
Nkosazana, ndivumele ndibiza amanqina amabini awaye kunye neclient yam ngelixa lesisiganeko to verify his claim.
Mr. Dambuza, ingabi prosecution ixelwe ngala manqina amabini?
Ndiyaxolisa wena mhlonitshwa, but the state submits that these so-called witnesses are not in any position to support the defense's claim that the sexual intercourse was consensual because they themselves assisted him in kidnapping the complainant.
Well, ndiyavumelana nawe Mr. Dambuza, kodwa ke ungaqhubeka Miss Mananga. In certain circumstances, in criminal matters, there are very few witnesses available, and it is not uncommon that there be only one witness. The court has to establish and must determine for itself that the witness does not have bad blood towards the accused, does not intend to unduly harm the accused, and that basically she, or he as the case may be, has no reason to give evidence about the accused that is not truthful. Remembering at all times that the court's intention is to arrive at the truth. And anybody who comes to give evidence with some subjective motive is unlikely to give the truth.
Mr. Masiza, are you aware that having sexual intercourse with a 15-year-old, even if she consents, it's considered statutory rape?
Bengayazi bona 15 years?
Oh, ndiyabona so bumazi kakhulu. So tell me, what would you have done differently if you had known that she was 15?
Can be more careful.
Oh, go more careful. More careful ngokubumxhila. More careful when you repeatedly raped her. Or just more careful not to get caught.
I told you. Uyawazifunela. Cinga ba wayi wena siqangola ngasemva livuliwe. Jini.
Ubushiya uvule ucango lwasebhek for yena?
Oluphi ucango? Hayi. Ayikho yonke le nto ayithethayo.
I don't see how intention could be lacking where Ukuthwala is practiced. Because remembering that whoever practices Ukuthwala has got a particular intent in mind. The intent is to secure a wife. So that is the intention element. However, what might be lacking is a criminal intention. A criminal intention refers mainly to an intention to do that which is wrong, that which is unlawful. So if you take somebody who lives in a community where Ukuthwala is practiced, and they practice in accordance with its prescripts, then one can't speak of unlawful intention or criminal intention in that case. But one speaks of intention generally because the intention for the person is to secure himself a wife and hopefully to live happily ever after.
Coming up, the court has heard Sipho's version, but will Lulama cope under the pressure of testimony?
Waye wandidlwengula kabuhlungu.
Zukhumbule ke sisiva, if at any time ufilisha uncomfortable undixelele yar, and then sayicima ikamera, i-court ithatha break till wena uphinde ube ready, then kuqhutywa kwakhona yeva.
Nkosazana uMsutwana, ngabe yandiva?
Ndikuva kakuhle nkosazana.
Very well then. Mr. Dambos, ngaqhubeka.
Lulama, in Ukuthwala, the procedure is that the girl is kidnapped and taken to the boy's family home. Ingaba uye wadibana nosapho lomangalelwa?
Uke wadibana nosapho lwakhe?
Hayi.
Lulama, did the accused speak of matrimony at any point?
Uke wayichaphazela nje indaba yomtshato?
Hayi.
Lulama, do you remember anything that he might have said at the time?
Ikhona into oyikhumbulayo ethethileyo kuyo ngelo xesha?
Waye wamane sithi mandiyeke ukhala. That I should feel lucky instead. Ngoba yena wayefunwa yinqwaba yamantombi. Kodwa yena waye waphandlwa ndim.
Ingaba wena uye wamcela ukuba akugoduse?
Uye wamcela ukugoduse?
Waye wathini ke Ian?
Uphendule njani yena kum?
Waye wandi bamba ngesixhanti. Wandiqamangela ngentambo zombane. Waye wandidlwengula kabuhlungu.
Enough, Mr. Dambos. Bambe kulo ndawo. The general rule of our law is that the accused is entitled to face his accusers. A distinction, however, is drawn between witnesses who are adults and witnesses who are children. The law now provides that where a child under the age of 14 gives evidence, that child will give evidence in camera. For a child above 14, the court has a discretion whether or not it should be in camera. Secondly, where a child is the complainant in a sexual complaint, the law dictates that that child will give evidence in camera. And the real idea is to protect the child from the hostile environment. Court by its very nature is hostile to people who are not accustomed to it, more so to a child. And if the presence of the accused while the child is giving evidence is going to hamper the child speaking freely, then in such limited circumstances, the court will order that the child's evidence be heard away from the accused.
At the end of the trial, the court found the accused guilty on both charges of abduction and rape.
Rise in court.
The next step was to determine an appropriate sentence for Sipho.
Inkundla ifumana umangalelwa enetyala ngokuthi ungabonakalisa inhlonipho nambeko kwisithethe sakwaXhosa. Ngamafutshane inkundla ithi uphule ilitye likaphungela. Kwisiganeko sokuqala sowuthatha ngolunye ufumana i-10 years.
10 years for abduction.
Kwisiganeko sesibini sodlwengulo ufumana 15 years. Court adjourned.
People who abduct, normally it's not just one person, it's the husband to be, if that person is going to be the husband, and other friends or whoever. All those people, if arrested, they are going to be convicted with the same conviction that the perpetrator himself is convicted on. For example, if the court will find that it is rape, all this will be rape because there will be accessories to rape. They will have assisted that person to rape the victim.
One has to accept that there are certain communities that for generations upon generations have lived with the custom of Ukuthwala. They either know no other form of getting a marriage together, or it is so prevalent as to be acceptable. But even when it is acceptable because it meets certain standards of the practice. Such communities, if the custom is abused, would be the first to frown upon it.
We have to go back to our roots to do things in a proper manner that we used to do in the olden days. Failing that, you will face consequences, and we will support the justice system with that regard. In that regard, we cannot act against that.
Now it is the era where we have a constitution. All the children have to go to school. You know, there's so much poverty that when you abduct a young girl, you are putting them in that vicious cycle of poverty where they are poor, their children are going to be poor, their grandchildren are going to be poor because always they'll be abducted and all those things. As it is practiced now, it is wrong and those people will be arrested.
Question really that we need to ask is, are we conscious of the fact that if we are shortchanging the children, as we are doing today, that in fact we are destroying the future of the society? So for me, there has to be a conversation that has got to be happening at so many different levels. But I also think that it has to be coupled, it has to go simultaneously with very strong action, that those who are responsible face the full wrath of the law.
The abuse of the traditional practice of Ukuthwala is a violation of human rights and impacts negatively on children's rights and on the rights to dignity, freedom, health, and education. When a minor witness gives evidence in a criminal trial, the court may order that the witness gives evidence with the help of an intermediary. During the intermediary process, the accused and the court can see the witness, but the witness cannot see the accused. The purpose of this is to protect the child witness from experiencing further trauma during the trial. The final verdict was brought to you by SABC together with the Department of Justice and Constitutional Development.